Good morning, folks. My name is Jim Reedy, and this is the New Hampshire Tech Alliance, and this is the HR Exchange, our June 9th meeting, our end-of-year meeting for this program year, 2020-2021, and here to talk about sort of a year in review. So I'm looking at the our room filling up here, and just give it a few more minutes, and then we'll get started. Hope everyone's doing well. Hope everyone is not suffering from Zoom fatigue and webinar fatigue. We are going to be back in person in the fall with the New Hampshire Tech Alliance, HR Exchange, and other in-person events. I think that COVID has taught us that we're also going to continue to do distance learning webinars, especially as we go into the colder months and when travel gets more difficult. That we'll probably do a hybrid of both in-person with the recording events. We actually started that pre-COVID, and we're going to continue that as we refined both technology staging and delivery of services. So let's get started. It is 8:15, and we're going to go through a year in review, and I'm going to just sort of talk about what's gone on in the last year and in labor and employment law in particular. But of course, what has gone on outside in the world with regard to COVID certainly had a very significant impact upon the workplace. And so we'll talk about that. We're going to talk about what's happened in 2020, because that definitely continued on in 2021. And then we'll have a preview of the remainder of 2021, both on a legislative and regulatory stage. And so any questions you can post down below. I'd be happy to respond to those. And let's get going. So this is not only a year in review, but also what's on the horizon. So yeah, I mean, thankfully, 2020 is in the rearview mirror and the pandemic is finally waning. I was listening to Sports Talk Radio this morning, and on my way in, and they said that, Fenway was nearly full last night. It was not a particularly good game with the Astros in town, but more than half the crowd continued to wear masks outside. And that is, of course, a personal choice. But the governor, who's fully vaccinated, was doing that, and it was met with some boos from the crowd. I think we're finding that level of resentment in the workplace now, too. And we're going to talk about that because with the CDC guidance that has come out with regard to masks and OSHA sort of lagging behind a little bit, there is some confusion. I think locally in Portsmouth, the mask mandate was lifted yesterday. So communities, even go down to the micro level of communities, having different standards. And then even a step below that for purposes of going into a store or a place of work, whether or not they have different standards. And even within the place of work, whether or not there's a distinction between the vaccinated and the unvaccinated, which there should be. And then for those that might wear masks out of respect for others, or just simply a belt and suspenders approach. It's I'm vaccinated, but I'm concerned about breakthrough COVID or other health issues, so I'm going to just continue wearing a mask. So we can talk about that, but let's briefly review sort of the workplace developments of the last year, and we'll go through it slowly because there's a lot, and I know you know this stuff, but let's talk about it because there is a tail to a lot of the things that go on that went on in 2020 that will have an impact, continue to have an impact in 2021 and beyond. So we all know that it was just over a year ago, well, it's a little bit more than that. In late March of 2020, the Congress adopted in 1 week the coronavirus, the Family First Coronavirus Response Act, or the FFCRA. And we all know what that is. We know that was emergency family leave, but it really wasn't family medical leave. It was you run down the FMLA clock, but it really was only if the daycare, the employee's child's daycare or employee's child's school had closed, that it was time off for the parent when there was not adequate childcare available. And that was at a certain percentage, that was the employees getting paid and the employer getting a payroll tax credit afterwards, quarterly payroll tax credit. And of course, the other was when the employee was exhibiting symptoms of COVID, or was exposed to someone, or had to be quarantined and so on. And that was a emergency sick leave. And there was a crossover between the two with regard to emergency sick leave and emergency family leave with regard to care for a child. So we all know that we became experts in 1 week. Now, I would say that is one of the most unusual things that we've seen in recent years coming out of Congress, in that a bill was proposed, written, and passed within a week. And with that, it's like, putting together a car that fast. There's going to be problems. And there were some unanswered questions. So the U.S. Department of Labor issued FAQs throughout the year, continuing to refine their guidance with regard to the many twists and turns that come up with just about any form of legislation or regulation. But what was interesting was shortly after that, so it's almost like that commercial late night TV from Ronco, wait, there's still more. So after the FFCRA came out, and just as HR was digesting what that meant and then explaining it to the C-suite and to the employees, and remember that the FFCRA came out at a time, late March, early April, when COVID cases were spiking in the US. There were stay-at-home orders, there were shutdown orders. And so a lot of employers, because they couldn't have people travel unless they were essential workers and so on, furloughed a lot of their employees. And so you're dealing with that, and then whether or not they're being paid through unemployment, or they're being paid through their PTO, or they're being paid through the FFCRA. And then along comes the CARES Act, the Coronavirus Aid, Relief, and Economic Securities Act. And basically what that was done is, as you all know, and again, that was shortly after, within weeks after the FFCRA, the criticism of that was it's sort of schizophrenic. And on the one hand, Congress is saying we want employees back to work. That's why we're proposing the PPP, the Payroll Protection Program. And that was to get employees back on the payroll. And if they were back on the payroll at the measurement point for purposes of headcount, then employers could receive effectively a no interest loan from the federal government. Percentages 75-25 for purposes of using them for payroll and so on. So administered through the Small Business Administration and through your bank, getting that relief was certainly welcome last year. It kept a lot of organizations afloat. At the same time, however, the CARES Act talked about augmenting unemployment benefits. So it seemed, as one senator described, as a bit schizophrenic. On the one hand, we want you back. On the other hand, we understand why you're going to stay out, and we're going to actually boost your unemployment by hundreds of dollars beyond what you would otherwise receive through state government. And in fact, there was a complaint that I can't get employees to come back to work for two reasons. One is they don't feel safe in coming back, or they are taking FFCRA leave, or employees simply some employees were actually doing better on the CARES Act augmented unemployment benefits than they were if they were at work. And that was the beginning of 2020 for purposes of, the first quarter of 2020 for purposes of sorting this out. Now, we thought by May, June, July, that this COVID issue would be resolved. With the warmer weather, people outside, with science attacking this virus, we thought everything would be fine. It wasn't, as we know. While things did open up a bit in the summer, then of course everything spiked again in the fall, and things actually got considerably worse for a period of time. Employers, of course, had to deal with that. Now, while that was going on, a very interesting development occurred, and I wrote an article on this recently. During COVID, that because of isolation, because of the unavailability of or poor access to healthcare for everything from routine visits, meaning not critical care visits, and elective procedures and so on, but even access to mental health providers and EAP. A lot of employers saw their employees who were isolated as the virus continued to wane a little bit. We're seeing more and more employees having exhibited symptoms of anxiety, depression, and so on. And also, the statistics are bearing out that there's been a significant increase in drug and alcohol abuse in the last year. Some of that makes sense with regard to isolation, remote work. You're not in the workplace, and so the drug and alcohol policies may not apply. Fear and anxiety over what was happening with the pandemic, and also, again, limited access to EAP and drug treatment facilities, alcohol treatment, and so on. At the same time, several states legalized recreational marijuana. You think, talk about odd timing. Arizona, Montana, New Jersey, and South Dakota. Now, a couple of them you can understand, but some of them are the more conservative states where South Dakota and Montana, you would have never guessed, gone to recreational marijuana. Now, nearly 40 states have legalized marijuana in one form or another, New Hampshire being the holdout in New England to just having medical marijuana, not recreational marijuana. The surrounding states around New Hampshire all have recreational marijuana, which, as employees return to work, of course, we're looking at perhaps updating our policies. The other reason to update your policies, perhaps with regard to testing procedures, is we're now back down to near record low unemployment numbers, especially in New Hampshire. From the spike of 17% unemployment during COVID, now back down to 2.3% in parts of New Hampshire, meaning that employers are desperate to find, and this is nothing new for you folks, desperate to find employees. And so therefore, whether it's enticing them with bonuses or it is saying, we're not going to test for marijuana at the application stage, the pre-employment stage, or during employment, that is something that employers are looking at. Now, that's one development. But another development that causes us to scratch our head is that possessing heroin, cocaine, methamphetamine, and other drugs for personal use, this bill passed in Oregon in this last year, no longer a criminal offense. And if you've seen this movie before, what happens is, what happened with marijuana was a decriminalizing of a certain amount of possession of marijuana, and then going to some form of legalization. This is a pretty interesting and, I think, somewhat scary development. Yeah. And many would agree. The New Hampshire Department of Labor, let's talk about their inspections in the last year. And I think what was interesting there is that their inspections went on, even though they were fully remote. The New Hampshire Department of Labor on the wage and hour side, fully remote. But they did still almost 900 inspections of workplaces, many of them virtual for purposes of requesting information, responding to calls, contacting employers, and so on. They assessed $1.6 million in civil penalties and fines, but they only collected about $376,000, where that is a lot of money, but that is not from just one employer, obviously. But actually, that's what that signal was. The Department of Labor understood that we were in the middle of a pandemic, and they actually took it easy on employers. What that also says in 2021 is, and beyond, that is likely not to be the case going forward, that the Department of Labor will be going back out to do their trainings again, and they'll also do the in-person inspections. And when that happens, they'll likely find more issues. The other is some of the latitude that was given to, or flexibility given to employers, both by state and now by federal investigators, is not going to be the case going forward. One, because we're back to work. The pandemic hopefully has ended. And then the other is changes in administrations and focus on certain things. And I'm going to talk about that in a minute. But the U.S. Department of Labor guidance, for the most part last year, was very helpful, because it had to do with the FFCRA. They did announce a final rule on joint employers, meaning when two employers are deemed to be acting in concert or could be deemed to be equally culpable for purposes of wage and hour claims. But that joint employer rule was later struck down by a district court. And they also clarified a rule with regard to independent contractors. See, this was up during the Trump administration, and they basically made it easier for someone to be an independent contractor. During the Biden administration and Secretary Walsh, the Department of Labor has already looked at revisiting both joint employers and independent contractors and going back to not only a pre-Trump or pre-Obama administration, actually going back to the Bush administration standard for purposes of independent contractors, which in essence is someone is deemed to be an employee unless they can meet the very stringent test of determining that an independent contractor. EEOC last year and the year before had postponed their pay equity data collection after their initial data collection of the 2017 numbers for purposes of determining wage rates and the potential disparity between, or apparent disparity between genders in the same pay grades and so on. That study is still underway. The EEO2 effectively has not been reinstituted, but it likely will be because it's a priority of this administration and the EEOC, looking at pay disparity and pay inequity between genders. But that is still being studied, and the results of the fiscal 17 data collection is being studied. And likely you'll see that after the report comes out end of this year, you'll likely see something in 2022. But what EEOC did last year was they focused on vaccine and testing guidance and pandemic discrimination warnings. What they're looking at there in that last part is discrimination against someone who's disabled or has a sincerely held religious belief as to why they are not getting vaccinated. But then vaccines and vaccine mandates, inquiries with whether or not you're vaccinated or not, asking for proof, and so on, or vaccination sites in the work site, incentives, and so on. In December of 2020, there was guidance from EEOC as the vaccines first rolled out. As recently as last week, EEOC came out with additional guidance with regard to vaccines. And yes, you can mandate the vaccine, but you also have to have carve-outs for, again, disability, medical reasons as to why someone can't be vaccinated, or a sincerely held religious belief that comes from the church doctrine, not just what the person actually believes the church says. You actually have to get into the church doctrine in that regard. But also some other issues with regard to inquiries and how far you go with your inquiries about why someone is not vaccinated and so on. From our experience, most employers are not mandating the vaccine. They're encouraging the vaccine, and what they're otherwise doing is they're saying, if you're not vaccinated, then we're going to ask you to wear a mask in the workplace until such time that the CDC or otherwise says that indoors the unvaccinated don't no longer have to wear masks. CDC or state public health officials. IRS, of course, they were focusing on PPP loans and the like, along with Small Business Administration. And what's going to come next from the IRS is tax issues and also the repayment obligations. And those are still in process, as we're just winding through. The PPP program is effectively ended, but now it's a matter of sort of the going back and auditing and checking. State officials are also looking at whether or not they can tax employers for the receipt of the PPP loans. And that is a hot button issue, not resolved yet. OSHA had a very interesting year last year. On the one hand, they relaxed drug testing. Yes, OSHA, the most conservative wing of the Department of Labor, and their focus is on the general duty rule and on workplace safety and removing all hazards or known hazards. um, relaxed their drug testing requirements with regard to DOT truck drivers because of delays in testing facilities or access to testing facilities, and also when someone actually might be at work because of changing shifts and so on. That does not mean that they otherwise have relaxed their standard with regard to drug testing. A year and a half ago, they did look at potentially getting away with certain post-accident tests or changing the post-accident standards, but that didn't really go very far. They have, however, in the last year, spent a lot of time. In fact, our contacts at the Department of Labor said their phone has been ringing off the hook with regard to COVID safety audits. And in that regard, we handle several for clients where an inspector actually comes into the workplace and also requests additional information. Everything from social distancing to access to bathrooms, meaning single-use bathrooms, closing down community kitchens, travel restrictions, quarantine afterwards, and again, masks in the workplace, and so on. OSHA was getting complaints from employees that did not want to return to work, or complaints from employees who were at work and didn't think their employers were following the safety guidelines for daily screening and so on. And so OSHA was very, very busy in that regard and continues to be. And they've issued new guidance with regard to return to work and return to work safely. I think we're going to likely see, in fact, we already are seeing more what's called 11C, Section 11C claims by employees who say they complained about workplace safety issues, in particular with regard to COVID, and they were retaliated against somehow by their employer, that they, weren't promoted, they didn't get the same pay increase, they were somehow shunned or frozen out from certain meetings and the like, and so on. So that's one you have to be very careful of. And why? Well, now we're in 2021 and we're looking at trying to get employees back to work and incenting, providing incentives, but also saying it's safe to come back. And, if you're vaccinated, if you're not vaccinated, these are the rules and so on. I've had several clients that have had the issue of employees who are fully vaccinated by their own admission still don't feel safe about coming back, or they prefer to just simply work from home, and getting them back to work. Some of those employees who are resisting coming back to work are actually dropping a dime to OSHA and making complaints. So that is something that you'll likely have to deal with, or you may have to deal with. If you do, make certain that your safety records are in good shape, and that if an employee complains about workplace safety, that you address the issue and the employee doesn't suffer any type of retaliation because of that complaint. You can still disemploy employees for other reasons, but be careful, especially when they file a workplace safety complaint. Another interesting issue from last year, remember the National Labor Relations Board changes with every administration, especially when you go from one political party to another in the White House. The composition of the board changes, and there was some controversy between the Trump and Biden National Labor Relations Board and how board members were removed by the current administration. That happens. But also what happens is there's a shift in focus between a Democrat or Republican majority on the National Labor Relations Board. Under the Trump administration, the board was a bit more employer friendly, and therefore they restored the employer's right to restrict access by unions and union organizers to email. There were a few other decisions that they made that were pretty interesting, but the concern was for employers as we shift to the Biden administration, whether or not that board was going to be more employee friendly and more union friendly. It probably will be, and we've seen some signs in that regard. But we've also seen a few signs that were actually interesting in that the board has issued decisions that were somewhat employer friendly. Now, they're also revisiting a lot of decisions that were made during the Trump administration and could likely reverse those. But what we've seen so far is not a significant shift, at least not yet. Workplace highs and lows in the last year. Basically, we'll talk about legislation and how it stalled in Congress. And this is very quick because this is going to lead into what we're talking about in 2021. proposed amendment last year to the Age Discrimination and Employment Act, the ADEA. If you've got more than 20 employees and you're covered by the ADEA, of course, you know the standards that if you have a separation agreement and release, you have to give the person who's over age 40 21 days to consider it. It has to be in plain English, that they have to understand they have the right for an attorney to review the matter. And even after they accept it, the severance, that they've got 7 days to revoke their acceptance, and so on and so on. And if it's a larger separation involving more employees, it's 45 days, 7-day revocation period, and a census that goes along for the affected employees. We all know that. This amendment didn't get at that. This amendment got at what is the standard for proof of an age discrimination claim? And when we ask every year, how many of the top 5 types of most common discrimination claims out there, where does age fit? And people think that age is usually at the top of the list. It's always at the bottom of the list in the top 5, even if it makes the top 5, because the standard of proof is different than other forms of discrimination, which is other forms of discrimination could be a mere preponderance of the evidence, meaning more than 50%. And you could have a mixed motive case, which is, it's discrimination on the basis of gender, and there are other things in the mix as well, and so on. But if gender's in the mix, or disabilities in it, or race or color are in the mix, religion and so on, then you could have an issue of discrimination. For age, it's a bit different because of a case in the Supreme Court, what was called the FLP Financial Services Gross case, that age had to be the reason for the discrimination. And because of that, these are difficult cases to prove. Because if you can show performance, attendance, insubordination, and so on, other issues, or just business necessity, a reorganization and so on, the claim should fail. Congress said that's not right. You've got employees that cannot properly advance an age discrimination claim when age was certainly one of the factors. And so the proposed amendment was to say that, to basically say if it is one of the factors, and perhaps even the motivating factor, but not alone, not the single factor, whether or not that is sufficient for purposes of proof. That did not pass Congress. However, it's back again, and it has a decent chance of passing into this Congress. The Paycheck Fairness Act has been kicking around, the Working Families Flexibility Act, also kicking around, for purposes of modernizing the FMLA. That also has been around. The Healthy Families Act, which is would require the mandatory minimum sick leave and so on. All stalled in Congress last year. Not a lot. And if you think about it, apart from partisan politics, you think about it, the focus of Congress in the last year really was coronavirus and providing assistance, whether stimulus checks or the FFCRA or the CARES Act and so on. So, and that was effectively it. Of course, then there was also the partisan divide because it was an election year. The last thing that that Congress looked at was protecting independent contractors from discrimination. Basically, that was taking, if you're classified as an independent contractor, we're going to give you the protections you would have if you were deemed to be an employee. That went nowhere. And as I discussed, that was because during the Trump administration, there was greater protection for independent contractors to establish that classification. And this was a pushback saying, yeah, well, even if they're independent contractors, we want to give them certain protections from discrimination in the workplace. Didn't go anywhere. In New Hampshire, we had some stalled legislation too. And let's go look back at Congress for a second. In Congress, you had a Republican president, a Republican majority in the Senate, and a Democratic majority in the House. And that sets up for, hopefully, you want to talk about bipartisanship, but that really wasn't the case last year. And it really isn't the case this year. But that's obviously different. What's happening in 2021 in Congress is a Democratic president, a Democratic Senate, at least a majority of one, and a slim majority in the House, a Democratic majority in the House. So as recently as, and we'll talk about this in a minute, this week through reconciliation, the Democratic majority is going to try to advance certain priorities. Last year, though, in New Hampshire, you had a Democratic House, a Democratic Senate, and you had a Republican governor, which meant that things would pass relatively easily through the House and the Senate, make its way to the governor, and he would veto them. And then you needed enough votes to override the veto, and that wasn't the case, and so things stalled. Even before it got to the governor's desk, you had matters of legislation that didn't go anywhere, increasing the minimum wage in New Hampshire in the middle of a pandemic from $7.25, which is ridiculously low, of course, to $9.50 up to $12 an hour over a period of a couple of years. Didn't go anywhere. Limiting access to criminal record checks was trying to follow suit with other states, including states like Massachusetts with the Corey law, saying that you can only ask about someone's criminal record once you've advanced during the hiring process. You can't exclude them just because they've had a record. You have to get to a certain stage. That went nowhere. Mandatory payment of vacation time also didn't go anywhere. Most employers provide some form of vacation or PTO. Paid family leave has been kicking around for a couple of years, and it came close a few years ago. But under this administration, the governor was at odds with actually a political rival with regard to different forms of mandatory paid leave. But it would come out of the employers. They would come from employers. They would have to pay leave, and there was a structure for purposes of the employers to get some sort of relief in that regard. But there was no momentum for purposes of passing paid family leave in the last legislative session. A little preview into where we are in 2021. We now have a Republican House and Senate in New Hampshire and a Republican governor. And so some of these may be back again. They are back again, but the question is whether or not a Republican legislature will pass these. And the answer is no. Pay equity wage data collection proposed on a local level, even though it stalled on a federal level. And we're not seeing that. Didn't happen last year. Drug test and marijuana use basically was to relax drug testing and because of the availability of marijuana. That would have been similar to the standard in Maine and in Vermont for purposes of drug testing. That went nowhere, meaning you couldn't have it at the pre-employment stage and so on. And mandatory paid sick leave, just like mandatory paid vacation time. The vacation time would have been allowing rollover and paid of vacation, accrued but unused vacation time at separation from employment. Sick leave would have been just simply a minimum amount of sick leave available to employees from their employer. Didn't go anywhere. And if you think about it, neither were really necessary with FFCRA, PPP loans, and other options available to employees last year, really not necessary. Some things that were under the radar last year because they were carryover from the year before in the biennial session was a bill that would have required notice 14 days in advance of a work schedule. So an employer had to give an employee 14 days notice in advance of changing their schedule. That seemed to be pretty awkward and inflexible, and most employers were opposed to that. Greater limits on non-compete agreements. We know that the courts have narrowed non-competes considerably. In Massachusetts, it's very difficult to have an enforceable non-compete, and even if you do, you have to provide what's called garden leave, basically paying someone to sit in their garden. It's a European concept, but it's made its way to the U.S. shores. But New Hampshire would have been just narrowing it further. And one of the things that did come up and did pass in 2019 was a law in RSA 275 that says you cannot have a non-compete agreement for a low wage earner, and the low wage earner would be someone who is defined as making at or below 200% of the current federal minimum wage, which if it's $7.25 would have been $14.50. So anyone making less than $14.50, you can't have a non-compete. Well, you wouldn't want a non-compete from them anyway, but could you have a non-disclosure agreement? Yes, you certainly could. Could you have a non-solicit? Maybe, but Are you going to really care about non-solicits for low-wage earners? Are you going to enforce against them? Probably not. But the courts continue to narrow that because the sense is that these restrictive covenants, post-employment restrictive covenants, have the effect of keeping someone from pursuing work. Space secured for nursing mothers. This was proposed before, it's proposed again. And if you're covered by the FLSA, the Fair Labor Standards Act, which you likely are, we know the amendments under the ACA of a few years ago talked about securing that space, a segregated space, a closed door with a lock on it, refrigeration for the nursing mother to store the milk and so on, and time for the nursing mother to express privately for the nursing child and so on. And this was to provide additional space, perhaps for those not covered by the FLSA, but also providing even greater protection for the nursing mothers. Great concept. It stalled last year. It's back again this year. Changes to criminal record checks for school employees. That actually was a good bill for purposes of boosting the criminal record checks and expediting them for individuals working for schools and working with children. And the governor proposed a COVID-19 immunity bill, which basically was it was proposed by the business community to provide protections for employers being sued for COVID arising from the workplace. Now, we know a year and a half into this pandemic that the science has evolved with regard to COVID and the causes and so on. And remember, initially it was thought that you could pick it up off of surfaces and so on. And then later that was debunked, but because it's an airborne virus, the question is whether or not you can prove it arose at work as opposed to at home or in the community. But the governor was proposing an immunity bill for employers so they couldn't be sued or there'd be a cap on damages arising from work. That didn't go anywhere. That's back in the legislative session this year. The thing to point out in that regard, what we do have in New Hampshire, unlike other states, we do have an attorney general opinion in New Hampshire that says that, generally speaking, that a claim for COVID arising for the workplace will not be deemed to be covered by workers' comp because you cannot prove it arose during employment. As many as 17 states, however, have amended their workers' comp statutes to add a presumption that, or a possibility that COVID did arise at work, and therefore the employee could make a claim for workers' comp, which is wage replacement and medical indemnity under the state workers' comp statute. We don't have that in New Hampshire, and that's sort of a double-edged sword. On the one hand, there's a cap on recovery under workers' comp, as you know. On the other hand, it actually does increase premiums because you're going to have more people covered under workers' comp. And the issue, as we covered in our most recent employment law seminar, is an issue of what's called long haul COVID, which is the long haul public health effects. I was in my town hall the other day trying to renew my registration on my car, and I was talking to the clerk at town hall, and she said she got COVID just about a year ago, and she still doesn't have. She has lung issues and respiratory issues, and still problems with taste and smell, restoring taste and smell. So there are other even more serious implications or health conditions that arise from COVID in some people. So that's why there's that push against workers' comp coverage for COVID that is deemed to have arisen in the workplace. On the other hand of the equation, however, you have health insurance carriers saying, why should we have to carry that burden when clearly workers' comp should cover that? So that's a battle that may continue in the legislature with lobbyists. A couple of cases that came up from the Supreme Court in the last year. Again, last year was a year of division within the court too, because of the passing of Justice Ruth Bader Ginsburg and the appointment of a new justice. And the question of whether or not you're going to have a 6-3 court, and with that, for a generation having a more conservative court. As we've seen the sort of the tail of the tape, however, with Chief Justice Roberts and others, That hasn't necessarily borne out as being an overly conservative court. You get a lot of 5-4 decisions, and even some that slide towards the more progressive side of the court, if you can assign politics to the court, which hopefully we don't have to. The Bostock case basically was a case that's been kicking around for a while in a couple of different matters, but Bostock basically got to the court as to whether or not gay and transgender rights are protected as sex under Title VII. Again, Title VII just basically defines sex. It doesn't define, it talks about protection on the basis of sex. And historically, if you remember, that was thrown in by, I think it was a legislator from Virginia back in 1963, 64, when the Civil Rights Act was being considered. And remember, largely the focus there was protection on the basis of color and, color. And a legislator from Virginia threw in gender or sex to the Title VII protections with the hopes of basically defeating the bill. Of course, that didn't happen, and sex was there. However, for the last 8 to 10 years, there have been a number of cases that say, how do we define that? Because a lot of state legislatures have protections on the basis of, including New Hampshire, protections on the basis of sexual orientation. That is not protected, had not been protected under the under federal law, under Title VII. There was the on-call case of a few years ago, but basically keep throwing it back to Congress. You fix it, you figure it out. Well, the Supreme Court did take that on in the Bostock case and basically said that gay and transgender rights could be protected as sex under Title VII. That is a significant change. Again, this is really something Congress should be addressing, but they hadn't yet, so the court finally stepped up and did that. And that was significant, as the court stepped up and addressed gay marriage a few years ago. The ministerial exception in the First Amendment to discrimination claims, First Amendment rights of the right to free exercise of religion, as to whether or not that was an exception to discrimination claims, meaning when you have a school and the school, there's a discrimination claim arising from an employee in the school system, a religious school, whether or not that person could advance a claim because the school has certain protections under the First Amendment. That case, Our Lady of Guadalupe, basically defined who could be protected by that. If you have a math teacher who's not necessarily following and is not ordained or following the religious doctrine of that school, is that person protected, as opposed to someone who's in the ministry and either ordained or following certain prescription of faith and so on. So that was helpful. That will continue to be tested. There are other cases before the court this year on that same subject, as there are a few issues left unaddressed. And Little Sisters of the Poor, that was an ACA exemption for religious and moral reasons. What are we talking about? The mandate for birth control and abortion services under the ACA, and the Little Sisters of the Poor in their organization and in their workplace questioned whether or not they needed to have those when they objected to those services as a part of the menu items available under their health insurance plan. And the court agreed that they could be exempt for certain religious and moral reasons from the ACA. Again, the National Labor Relations Board and in 2020, again, tilting more towards the employer, greater confidentiality in workplace investigations. And I love this one. It revisited a standard for offensive outbursts in the workplace. There had been a shift in the court, in the board decisions when there was, if an employee screamed with obscenities but mentioned terms and conditions of employment, that was protected speech. The board said, not so much. If they utter certain vulgar terms, it may not be protected speech. And that was the last year's board. Question is whether or not this year board will flip that one decision or that one standard. The U.S. Department of Labor, apart from all the wonderful things they did with the FAQs with regard to the FFCRA, they did propose making more investments in apprenticeship programs. And I think that's critical both on a federal and state level because of our aging workforce and the importance of introducing younger workers and also just repurposing certain workers from certain industries to others, growth industries, as we perhaps transition from fossil fuels and so on. That sort of went under the radar from last year. And likewise, the proposed changes to FMLA forms. In the middle of a pandemic, who cares about changing your FMLA forms? Can we focus on the important issues? But that comes up every couple of years that the U.S. Department of Labor continues to sort of refine their processes and their forms, just like the USCIS does with regard to the I-9 form. Now, speaking of the USCIS, you had a freeze on non-immigrant visa processing in the last year and in the last administration. That has to change. That will be changing under the current administration. As you know, there is a shortage of skilled workers in a number of different areas, whether we're talking about the H-2B and migrant farm and agricultural workers, to seasonal workers, to hospitality employees, and then H-1B, the skilled workers with at least a BA or BS or other advanced degrees. We need to bring in more skilled workers into the U.S. From abroad. And I think we'll be seeing that. But the change in at least the freeze from the USCIS in the last administration. Some of the priorities in the current administration include increasing the minimum wage. We've already seen that through an executive order from the president with regard to federal contractors. EEOC is changing their priorities. They're focusing on pay equity. And of course, we're going to see pay equity legislation coming along. But the regulation on the EEO2, I mentioned that earlier, will be likely reactivated after the study comes out at the end of this year. Legislative priorities finally for Congress to step up and address LGBTQ plus rights under Title VII and codifying those. Religious exceptions continue to be tested. It's the push and pull of the conservative and not so conservative issues with regard to exemptions under federal discrimination law. More accommodations for pregnant workers, at least are on the docket from Congress. Updates to age discrimination laws, and that's what we're talking about changing the standard to make it easier for age discrimination claims to advance. And I just mentioned changes to immigration laws. So yeah, the vaccines are here. Can you believe it? I mean, I was listening to a podcast about the vaccines and the evolution of that, and how a year ago and even last fall, that many in the scientific community said that it is impossible to develop a vaccine that quickly. And I think generally speaking it is, but an enormous amount of money went into developing the vaccines and great incentives to Big Pharma. And of course, Big Pharma gets the plus end of that for purposes of the amount of money not only invested initially, but going forward in the vaccines. But in December, as we all know, you had Pfizer come out first and followed by Moderna, and then Johnson & Johnson and AstraZeneca behind them. And the first three having emergency use authorization from the FDA, and all great news. And, I think the current numbers are up to about 140 million or more Americans fully vaccinated at this point. And that's a wonderful development. So EEOC comes out with their initial guidance in December of 2020 with regard to vaccine mandates and related inquiries. And in short, it basically says that, said then and said again last week, that yes, employers can mandate the vaccine if it is consistent with the job duties and business necessity. The employer's larger business necessity. That's fine. And it also had the carve-outs for religious and for disability reasons. But managing the accommodation, the opt-outs was the real challenge for HR professionals, of course, and it will continue to be. Look around your workplace now. As I just looked around mine, you find many people without masks, but still many people with masks. And the question is, can you ask someone if they are vaccinated? And the EEOC says, yes, you can. Can you ask them for proof of vaccination? And the EEOC says, yes, you can. Can you ask, why aren't you vaccinated? No, you cannot, because that gets into inappropriate disability, potentially disability-related inquiries. So because you might then, through that, find out about someone's hidden health issues under the ADA or GINA that you may not need to know. Can you have vaccine incentives? The answer in December and again recently was yes, you can have incentives for people to get vaccinated. But it generally follows the wellness guidelines of a few years ago from EEOC, but you have to proceed with caution in that regard. And again, crossing over from EEOC to CDC and then to OSHA, you have to be careful because you don't want to have a situation where, one, you stigmatize or potentially discriminate against those who are not getting the vaccine, or you're not reasonably accommodating those who have a good reason not to get the vaccine. So what does this mean for HR professionals? It means your ever-evolving policies, your safety policies with regard to masks, bathrooms, kitchens, travel, quarantine, isolation, and so on. Remember just a year ago, we were talking about screening employees as they return to work in some capacity, and everything from daily temperature check to have you been exposed to, do you have symptoms of, and so on. And the question is whether employers are still doing that. Largely, employers are not doing that, but they are keeping an eye out under their safety policies and continuing to basically encourage sick employees to stay home. So a couple of weeks ago, I think it was May 7th, CDC came out with their Friday surprise announcement with regard to, and it was just a couple of weeks before that, they were talking about the continued use of masks, not only outdoors, but indoors, or vice versa, not only indoors, but outdoors. And then it seemed like out of nowhere, the CDC changed their guidance and said the fully vaccinated no longer had to wear a mask outside or inside. That threw national and local, state and local authorities a bit for a loop, and it certainly did with the with OSHA. And a lot of employers were left saying, "What does this mean?" CDC has updated that guidance. OSHA said initially that they'll follow CDC guidance and they're going to try to issue their own. But in short, what it means, and a lot of states have continued now to follow this, is they're saying if you're fully vaccinated, you don't have to wear a mask outdoors or indoors, and so on. But a lot of employers are basically saying, we're going to leave it up to the vaccinated if they want to continue to wear a mask, but the unvaccinated should continue to wear a mask and socially distance. Can you require proof? You can. Sadly, I've already heard of a black market for vaccination cards or counterfeit vaccination cards. That's truly unfortunate, but that's American ingenuity for you. Unintended consequences, I think it was just the confusion in the marketplace with regard to masks and what that meant in the workplace. But I think a lot of employers have since in the last couple of weeks worked that out. So you've got the state guidance, you've got local, you've got this, the state mandate in New Hampshire changed, and then New Hampshire shifted to best practices. The problem with that is business to business, there are differences. The conflict that could be coming in that regard would be for those that would claim that they were discriminated against because they're wearing a mask, or that there are improper inquiries with regard to their wearing a mask in the workplace. We talked about the American Rescue Plan at our most recent employment law seminar. That is the signature act by the Biden administration so far, early in their new administration. And it was a continued bailout for individuals, but also the American economy, and principally focused on certain industries like the hospitality industry and so on. But direct stimulus payments, we know what that's about. The biggest one there is, I think, for employers is the COBRA premium subsidy from April 1 to September 30. Displaced workers, meaning those that are eligible for, if your workplace is covered by COBRA, 20 or more employees, and you've got someone who is involuntarily discharged from the workplace, except for gross misconduct, they get their COBRA. If they elect COBRA, or even if they didn't elect COBRA and now they elect COBRA during this period of time, the employer pays the full premium and gets a tax credit afterwards. And again, that's only for the period up until September 30. There are other pension fund issues with regard to fund stabilization payments from the American Rescue Plan, individual tax credits, rather to principally child tax credits, and so on. There were business tax credits that were extended to September 30 for the FFCRA, and also you could get the FFCRA expanded for those who are getting the vaccine or recovering from side effects from the vaccine. Unemployment benefits. This is an interesting one because unlike the unlike the CARES Act, where it went to as much as $600 per week on top of what was available from the state, this is $300 per week on top of what is available from your state. But a lot of states are breaking ranks and not accepting the additional amount of money because they don't think it's necessary, and two, they think that it is keeping employees from going back to work. New Hampshire has taken one additional step, which is requiring in order to be eligible for unemployment benefits, you must be continuing to look for work. That was suspended during COVID because there weren't a lot of jobs available, and we wanted to keep people home and isolated. That is no longer the case, and so the governor just about a month ago reinstituted the requirement to be eligible for unemployment benefits. You must show that you're searching for work. So we have a couple of changes in the federal focus under the Biden administration. You've got former mayor of Boston, Marty Walsh, is the new Secretary of Labor. He's looking to roll back certain Trump-era regulations. We talked about that earlier with regard to joint employment, independent contractors. But the one I want to point out here is the pre-litigation liquidated damages. If you've had a U.S. Department of Labor audit, you know that the labor investigator and his or her supervisor can say, you know, we're going to propose these civil penalties for your shortcomings under our federal wage statute, under the FLSA, and you can pay now, or we can double the damages because we found that it was a willful refusal to pay or willful violation. That was not the case under the Trump administration. That is the case they're looking at now, as it's a bit of a fulcrum to get employers, one, to comply with the FLSA, and two, to settle up these cases earlier instead of going to litigation with the Department of Labor. Whether or not the National Labor Relations Board under the National Labor Relations Act is going to shift back to pro-employee decisions, not so far. We've seen a couple of things with regard to, again, access to email, confidentiality, offensive outbursts in the workplace, and a few others that suggest that this is a balanced board, at least so far. The IRS, they're going to be focusing on the final rounds of the PPP audits and the like, as far as deciding whether or not the PPP advance is fully forgiven or if it's a low interest loan. And now the EEOC's COVID guidance is largely over, although continue to have some of that with regard to discrimination in the workplace related to COVID and COVID accommodations. They're going back to their new 5-year strategic enforcement plan and their new priorities under the new commission. Some bills that are in Congress right now: Paycheck Fairness Act, which looks at wage and payment equity issues and boosting the protections under the federal Equal Pay Act, the FMLA Modernization Act, which basically one proposal was to drop the threshold number from 50 employees down to 25 employees. That really isn't going anywhere, but this one would basically be like the Small Necessities Act in Massachusetts, where an acceptable reason for intermittent leave would be to attend a child or grandchild's school events. Workforce Mobility Act basically is to its protections with regard to remote workers. The Right to Organize Act would basically make it easier to have union elections. And the Unemployment Insurance Technology Modernization Act would basically invest money in modernizing the technology for the processing of unemployment claims. One of the truly sad events in the last year, in addition to the obvious with COVID, was the amount of fraud that came up with regard to unemployment claims. An enormous amount of fraud, both here on a local level and on a national level. Individuals getting information and filing unemployment claims and then later filing tax returns for employees. That is something that was addressed here in New Hampshire and as well as on a national level. And one of the benefits of boosting the technology and data is data protection on a federal level. Workforce Data Act basically is with regard to certain protections of, again, personal information. The American Apprenticeship Act would be investing more money in apprenticeship programs, and that's a good thing. Protection older workers against a Discrimination Act is on the Senate side, is what we talked about, lowering the standard and making it easier for age claims to advance. And the FLSA Modernization Act would largely focus on increasing the federal minimum wage. Regulatory developments, again, the U.S. Department of Labor is looking at the independent contractor status and update a sea change from the Trump administration, changing the joint employer standard that was struck down by the court in New York, and then again, return to pre-litigation liquidated damages option in investigations. OSHA, they're increasing their investigations, COVID related and coming out of COVID. Their focus is truly the return to workplace in a safe way. And again, as I mentioned earlier, their emphasis on 11C retaliation protections. That's one you really have to watch out for. EEOC, their guidance certainly was useful with regard to the vaccine, both in December and again more recently. We talked about their 5-year plan, the EEOC, the EEO payroll protection program, payroll data collection, I should say, and whether that will likely be revived. But what they're focusing on is new discrimination claims, and that is for migrant workers and also on sexual orientation claims and transgender and gender identity claims. And that's their new focus, and as well as pay equity issues. National Labor Relations Board is going to return to what they say, even though there's been a bit of a balancing here. And the balancing is employer policies with regard to blogging, solicitation, and signature blocks are still lawful for now. And that's a tilt towards the employer side of the equation. What are we talking about there? Employers basically saying you can't have certain things in the signature block, XYZ Corporation, your phone number, your email, your mail address, and so on. And whether it's everything from preferred pronouns to making other statements, whether or not those could be included in the signature block. If it's a person's personal email, that's one thing. If it's the employer's email, that's something else. And then overly broad confidentiality policies, that was actually a Tesla policy that was struck down by the board. And that shows that tilts more towards the employee. But what the board is saying is they're going to be, and I actually listened to the new chief counsel for the National Labor Relations Board in a webinar the other day, and he said that there is going to be a more vigorous enforcement of employee rights under this board than there was under the previous board, which again is not uncommon. IRS is going to basically looking at whether or not the safe harbor for small businesses to claim deductions for PPP, both round 1 and round 2, they're going to be re-examining that. They're going to look at connection between tax returns and unemployment comp exclusions, and they're going to look at dependent care. They've issued guidance, but they're going to continue to look at the taxability of dependent care assistance. USCIS did, well, they may reopen the H-1B petitions that were previously denied under the last administration. We've already reached the caps for the this fiscal 21 year, but they're looking at potentially expanding that as well. And F1 students seeking OPT optional practical training can apply for that online. That is one of the new developments. The CDC, we know that they issued the new guidance that we talked about a minute ago, but they're investing nearly $2 billion to enhance the tracking of variants to try to stay ahead of these and therefore issue guidance that is more timely in that regard. And they want to update their travel restrictions because state by state, there is confusion. One of my kids lives in Hawaii, and of course, that's a different standard than other states as well. No news on vaccine passports yet, but that is something that some states have proposed, and especially if there's a return to or another wave of COVID. But New Hampshire has said, the governor said most recently, no vaccine passports here in New Hampshire. Some of his priorities continue to be the COVID immunity bill that we talked about earlier, investment in not only education and workplace training, but also in workforce housing. For any of you that live in New Hampshire, you know that we have a crazy housing market, and we need to have more affordable housing so we can attract people to the state and we can keep them employed here. Paid sick leave and PTO cash out, those are actually proposed again in this legislature. Mandatory minimum paid sick leave and cash out upon separation from employment. And pardon me, as you know, the standard under our state law is payout of PTO is only, or vacation only, if it is your employer practice or policy or both. If it is not your practice or your policy or both, then it's not due upon separation. So, and this would basically make it employers have to pay accrued but unused PTO, particularly vacation time, upon separation. An increased minimum wage, I think, is unlikely under this administration. A right to work came back to the House and it failed last week. Right to work would have been you cannot, as a condition of employment, require employees to join a union. We would have been the only state in New England with right to work. It passed the Senate narrowly. It went to the House and it failed. Are we likely to see more employer-friendly bills? We've already seen some. One bill that was a bit controversial, actually very controversial, was House Bill 544, which was an answer to critical race theory training in workplaces. And I'm talking about workplaces and not in schools. And it basically was prohibiting divisive language in training. The BIA and members of the legislature have come out opposed to it. HR associations like the Manchester Area Human Resource Association has come out opposed to that, saying, look, can we have more of a dialogue and less sort of this balkanization or divisive language on both sides of the aisle. And there are benefits to both sides of this controversy, but we can't have one way or the other. We have to have a discussion or dialogue. And 544 would have been, well, I'll just leave it aside that said it's likely not to pass. Close at home, workplace bills, and again, we're talking about COVID protection. We'll see one form or another that comes up from this legislature. Paid sick leave is dead on arrival in this legislature right now. The increase to the state minimum wage was retained in committee. But the one thing that did make it through is retaining wage and time records electronically. Finally, New Hampshire is recognizing that, you know, the technology that's available through HRIS systems. And so that is something that we're going to see that is going to be available for employers. I think the only other thing I want to talk about with, well, we did talk about the reasonable accommodation for pregnant employees and break time and space for nursing. That was sent to a study committee, but that doesn't mean it's dead. That just means it's going to refining it, and the bill will come back in the next session. Workplace safety issues are rising out of COVID. I think I mentioned that earlier. OSHA inspections are on the rise. I think we're going to see updates to marijuana and drug testing. Vaccine and mask policies will continue to evolve. Opt-out claims, I think you're going to see, for those that opted out of the vaccine, you may see discrimination claims arising from that because of views of disparate treatment against the employee for opting out of the claim. Incentives challenged, possibly, but I think the guidance from EEOC last week will make those less likely. And discrimination claims will increase based upon directives from employers for employees to return to work from remote work. Study came out from Bloomberg recently said that up to a third of American workers who are asked to return to work from their employers will look for work elsewhere. You will find discrimination claims from those that say, I'm disabled, I don't feel safe about coming back to work yet, I don't believe my employer is invested in safety in the workplace, or I've worked fine from home, I need to care for someone who's disabled, I need to care for my kids, and so on. So I think you'll see more of those claims coming up in certainly in the next year. At the same time, you have I think it was an article in Fast Company where a majority of CFOs and CEOs that were polled said that they thought that remote workers lacked hustle and they didn't have the same work disciplines as if they were in the office. So that's setting up for, I think, potential conflicts going forward. A couple of quick cases before the Supreme Court, one with regard to computer access and the limits on that with regard to improper use by the employer. You've got the ACA. Now that the individual mandate was eliminated under the Trump administration, whether or not the ACA is effectively, it cannot proceed. We've seen this case before a couple of times. What saved the ACA last time was the taxing power of Congress, but without the individual mandate, which is effectively the taxing authority, whether or not the ACA can continue. We'll see. That will be the true test of this 6-3 majority in the Supreme Court. And then arbitration and the authority of the arbitrator is the Schein case, and we'll see how far that goes with a lot of employers opting for arbitration as opposed to, for purposes of dispute resolution, as opposed to going to court. So those are in employment agreements or otherwise. So hopefully in the rest of 2021, we'll see an end to COVID, an acknowledgement that regulators are going to give us a break or continue to give us a break as we emerge from this pandemic and will not be too aggressive with regard to wage and hour safety claims or discrimination claims. Better agency processing discrimination claims, because even before COVID, when a lot of the agencies went fully remote, there was very slow processing of these claims, 2, 3, 4 years. Hopefully better investment in those agencies so they can process the claims sooner. That's for the benefit of the individual and for the employer. Clarity with regard to PPP repayment obligations. Hopefully we'll see more of that from the Small Business Administration and from the IRS. Finalizing the FFCRA credits, payroll credits. Common sense applied to the National Labor Relations Act by this new National Labor Relations Board. And I think, again, so far we've seen that. Cooperation to branches of government, boy, that would be a welcome relief. Likewise, civil dialogue in the workplace and in our communities, leaving the balkanizations of the past, hopefully, and to the extent that there are issues with regard to inequity, and there are, and with regard to injustice, historical or otherwise, that we can have dialogues instead of disputes, and hopefully with that collective change. And of course, the Red Sox and the Patriots returning to their glory. Most of this is a wish list and not an absolute prediction. So the employer focus clearly in 2020 was FFCRA, CARES Act, safety policies, and addressing employee safety concerns and accommodations. Post-COVID, while it's still with us, we've learned a great deal, and now we're focusing on getting employees back to work and taking the next steps towards whatever it is our mission and purpose of our organizations is, but certainly complying with applicable state and federal laws. There is no question, never a dull day in HR. I hope this review has been helpful and update has been helpful for you. As we look to 2021, the fall of 2021 and program year for 2022, we will start establishing those topics soon. We expect to be back in person as we were pre-COVID in September, and we look forward to seeing you all. In the meantime, I hope this has been helpful, and you can always reach out to me offline with any questions. So what do we do from here? Take a deep breath. It is going to be okay. Prioritize your changes because 2021 could still be a bit bumpy. Join LaborNet. Stay tuned to She Infinity for updates. And again, we'll look forward to seeing you again in September. Thanks so much. And there are the credits available for today's program. 1.25 SHRM credits available, and that's the certification standard and the code number. I'll leave that up to you for a second. Enjoy this day. Thanks so much.